Death of a spouse or parent, trust administration catastrophes. Your speaker for today's program is Jack Stevens. You can send chat questions at any time by using the chat window located to the right of the presentation screen. A question and answer session will follow the presentation. I will now turn the call over to Jack. Please begin.
Good morning, everyone. This is Jack Stevens calling. How are you doing? If you have your webinar, your monitor on, you can see the title of the webinar. We're having a little technical problem on moving the presentation, so I will be indicating next to the operator for her to do that for us. Anyway, it's been a while since I have spoken to many of you, and I look forward to hearing from any of you regarding the presentation here today. We are about to enter into the realm of trustee responsibilities, duties, rights, so to speak, and discretionary authority. And it's incredibly important that you take good notes, I think. And hopefully you have some trustees in, whoever is going to succeed you, because what we intend to do is try and make life easier for your successor trustee by some of the pitfalls that I have encountered in my experience with drafting, administering trusts. And what I mean by that, administration is on the death of a spouse, on the death of a parent, the necessities that we have to address when administering the trust, making sure everything is done correctly and prudently, and ultimately distributing the estate. Okay, we're going to start. If you'll move the presentation to the first page, please. And I don't see it coming up, at least on our screen.
Yes, I am on the second page, File Original Will.
All right. We don't see that here, at least. I don't know if our attendees can see it, but we certainly don't here. I will go forward then, and hopefully we can get that technicality satisfied. The first thing that the trustee needs to do is to file the original will. The county will not accept a copy of the will. It must be the original. So we want to make sure, and you need to make sure as the creator of the will, that you have your original in a safe place where your successor knows where it is. Many people keep this in their safe deposit boxes and banks. Others keep it at home in a lock box or whatever. Just make sure your trustee has access to it, because that's one of the requirements of California, that even though we are not creating a probate estate, we do have to file the will, and it must be the original, and get that accomplished early. Secondly, we prepare what is known as a certification and affidavit of trust. And that document gives the successor trustee, and when I say successor trustee, that's the person that succeeds you as trustee on your death or disability. That person steps into your shoes. And we create what is known as a certification and affidavit of trust under the probate code to provide them with authority to take care of matters at banks, investment institutions, anything that has to be done with real property, whatever, that you could do as trustee, they can then do as trustee. So it's a very important document that we prepared during the trust administration, and it indicates that they are the trustee, the acting trustee. A third important procedure that we go through, and some trustees overlook this and take it very lightly. But in some cases, it has come back to haunt them, the fact that we must give statutory notice to all beneficiaries and heirs under California law of the right to see a copy of the terms of the trust. The terms of the trust that become irrevocable on someone's death. So if we have a couple, a husband and wife situation, and let's say we have an AB trust, then that trust, the B portion, which is the decedent's portion in our trust documents, the B trust becomes irrevocable. And once it becomes irrevocable, we need or are required, the successor trustee, and that's usually the surviving spouse who becomes the sole trustee, must give notice to all beneficiaries listed in the trust and any heirs at law, typically children, that may not be beneficiaries for whatever reason. Maybe they've been specifically excluded from the trust estate. But they are entitled to notice of the right to see a copy of the terms of the trust that become irrevocable. And we send those out to each of the beneficiaries. Now, I must caution you, and something you need to be aware of, that means all beneficiaries. That includes any specific bequest that you may have made or are going to make at the time of your death. So you may leave $5,000 to every nephew or niece. You may leave a specific bequest to a longtime caretaker or whatever. But anyone that is a beneficiary of the trust then is entitled to see a copy of the terms of the trust. And that may be very important to you because all those people are going to see who gets what in your estate. Remember, a trust is a private contract. We don't file it like we do a will. So that remains private even after your death. So you need to think about this very seriously, about the number of people who are listed in your documents and charitable organizations possibly, or any institutions that you're leaving funds to. They're going to see how all of your estate is distributed. Also, if that's not bad, California has enacted a law that says if you amend your trust over a period of time, and I have clients that have amended their trust for many, many years. Some of them have 6, 7, 8 amendments. Well, guess what? All of the amendments have to be included with the trust. So if you have changed or disinherited a child and brought the child back in, or subsequently disinherited other beneficiaries that were originally in your trust, there's a history there that's going to be laid out for all the beneficiaries to see and heirs at law. How do we avoid that? And I had that addressed many times when clients come in to amend their trust, and we talk about that issue. We do a restatement. We restate the trust in its entirety. If we do that under the California Probate Code, we've superseded the original trust and all the amendments to it, and we don't have to then send out that original trust and all the amendments. All we need to do is send out the restatement of trust. And that's all the beneficiaries and heirs at law see. Your last intent your last designation of beneficiaries. So, as I have indicated in previous newsletters, you need to seriously think about this. If you have a history of amendments, you may want to supersede all of the amendments, the original trust, with a restatement in its entirety. We don't have to refund the trust because whatever's in the trust stays in the trust because we keep the same name and the same date. But it does offer a solution to this very real problem of allowing all your children, grandchildren, or other beneficiaries, nephews, nieces, whomever you've named. It could be a housemaid. It could be someone that maintains your lawn or whatever. If you've left them a specific bequest, we can restate that trust in its entirety and avoid that kind of situation. That is a major solution to a major problem. I'll have to tell you, when children, when their inheritance has been either voided or diminished, they can get upset, as you may well know. But we have other clauses that takes care of that. But in order to avoid them seeing this over a period of years, I highly recommend a restatement of your trust. If we have an irrevocable trust, that trust then must have a tax ID of its own. Next, please. We're starting another slide. I believe that's correct. I can't see. The monitor doesn't show me, but I believe that's correct. I might have to rely on the operator to follow along. Okay. That's good. The tax ID for the B trust, if we have a deceased spouse, or if we have a deceased parent, that trust needs to obtain, and we obtain it through our office with the IRS, a tax ID, because someone's going to have to pay income tax, and that the bank or the investment institution or whatever is going to report that on the Social Security number that they have, the tax ID number. So once the individual is deceased, we typically replace the decedent's Social Security number with a trust tax ID number. And then we administer the trust with that account under the trust tax ID number. That's very important because as trustee, if you succeed someone, like a parent, if you utilize your Social Security number and replace it on the account, guess what? All the income is going to be reported to you on your Social Security number for all the beneficiaries. So as a successor trustee, you don't want that to happen, and certainly we advise you of that when you come into the office for the trust administration. Another issue is clearing title to property. And what we do is we remove, by clearing title, remove the decedent's name from the property so the successor trustee, whether it be the surviving spouse or a child who's acting as successor trustee or whomever, then replaces the decedent's name on the deed. And we do this by way of an affidavit of death. So then that individual can deed the property to the heirs or other beneficiaries, or if they're selling the property, take it into escrow and properly sell the property. So that's an important step that we also take during the administration. And of course, we have to remove the decedent's name because if you go into escrow with property or sell it, under other circumstances, the buyer is going to look for whoever's name is on the deed. And certainly at that point, it would be very difficult for the decedent to convey property. So that's why we clear the property to make it easier. Again, all of these steps are for the successor trustee to make an easier transition into their responsibilities. I want to move to the AB Trust. For those of you who are married and have AB Trust, there are some important considerations. There is a formula clause in your trust that divides the trust on the death of the first spouse. Typically, and I'm going to say typically because of the community property laws that we have in California, we divide the estate and fund the survivor's trust. That's in my practice and in my office, the survivor's trust is Trust A. And we put the survivor's separate property and one half of the community property in that trust. The balance of the property, usually the other one half of the community property, goes over in the decedent's Trust B. And we do this on ledgers. And it's important we make a record of this so the surviving spouse, as the succeeding sole trustee, knows exactly what assets are in the Trust B, what assets are in the Trust A, because there are different rules that govern each trust. The surviving spouse has certain access to the B Trust depending on what you say in your documents. And that is access to income and, under certain circumstances, principal, which we'll discuss here very shortly. Also, we have what is known as portability under our present law. Portability is a very important technique that we have included under the flexibility provisions of our AB Trust that allows the surviving spouse to utilize the decedent spouse unused portion of the federal estate tax exemption. And that sounds a lot like gobbledygook to some people, but let me explain. Let's say that we had a $2 million estate. If we put $1 million in each trust, under our present law, the surviving spouse could utilize $4 million of unused exemption because we have a $5 million exemption. So she could use that through portability and add that to the exemption amount that she has for the remainder of this year. Or if Congress extends portability, they may allow the surviving spouse to continue that for many years to come. So if the exemption dropped from $5 million down to $1 million and the surviving spouse's estate exceeded $2 or $3 million at the time of her death, that portability would be there to protect from federal estate tax. That's if Congress extends the technique of portability. And are they going to? I have no idea. We do know that our exemption of $5 million expires December 31st. And on January 1, in the present law, we revert back to a $1 million exemption for each individual. Will Congress do something about that between now and the end of the year? I highly doubt it. In an election year, it seems that they can't get along anyway, and especially in an election year, I don't see that happening. However, after the first of the year, maybe in the spring, they could compromise on an exemption amount and make it retroactive back to January 1st, that remains to be seen. We'll just have to see how that transpires and what happens in the election. But from a planning point of view, you need to retain your AB trust and not go to a simple trust. I know because of the $5 million exemption, I've had clients, or I've seen people who have been referred to my office that indicate some attorneys said, you don't need this AB trust because you've got a $5 million exemption, but that expires at the end of this year. If you're safely under $1 million or so, okay, that's not a problem. In fact, I have converted some of our clients to simple trust because of the market the way it is, the real estate market, and they are significantly under $1 million, and that's okay. But let's see where this goes and put all the flexibility you can in your trust, like our survivors provision and our portability provisions. Put that in your trust, because once a spouse passes away, it's too late to include those at that time. Finally, as far as, and I say finally, there are other issues that crop up in trust administration, but to document everything we do, and that's next, please, if you would move the PowerPoint presentation to the next slide. Everything we do is to document with what is known as an action by trustee. This is a document that gives protection to the trustee. It demonstrates that they followed what was in the trust, what was dictated in the trust, and we memorialize that with this document. And it follows the division of the trust, if we have an AB trust, or if it's a child who is acting for the parent, it memorializes the payment of taxes, the payment of last debts, and also the distribution provisions were carried out, showing that they took the action that was in the trust, and we memorialize it in that document. If your trust during the administration has what is known as protective inheritance trust provisions, and please move to the next slide, please. In protective inheritance trust provisions, what are we doing exactly? We're making a condition of distribution to our heirs and beneficiaries. Why? Because people get sued. Our children get sued. Our children go through divorces. Our children have creditor issues. There could be bankruptcy or whatever. If there are legal proceedings that are overshadowing your children or heirs or beneficiaries at the time that the trust is to be distributed, the protective inheritance trust, I wrote these myself, incidentally. If you read, I started doing this about 12 years ago when I had some clients. I had one client who was involved in a divorce, a daughter. She contacted the office and said, Mr. Stevens, I inherited 2 properties from my parents, and I took and sold the properties. There were 2 rental properties, and she sold them at a time that was a good time to sell, actually, and took the proceeds and put them in a joint account with my husband. And I think it netted out to about $800,000. They had a joint account of $100,000, so that made that joint account about $900,000. They utilized the account to live on. They both contributed their wages into the account. They both wrote checks on the account, et cetera, et cetera. So it commingled everything. Well, the bottom line was the husband filed for divorce about 3 years later and claimed 1/2 of the account. And the presumption was that the wife had made a gift to the community property estate. And these are the sort of things that we try and help our children with, or grandchildren, or whoever your beneficiaries are. And as the creator of the trust, you can implement the protective inheritance trust provisions, which basically does two things. It's a condition, two conditions in your trust. Number one, it makes it a condition if your child or other beneficiaries, whomever is involved in a legal proceeding at the time of your death, their share is withheld and not distributed. Because once it's distributed, it gives the opportunity for any court to possibly make any orders in regard to any funds that are coming into that child's estate. So if they're involved in a bankruptcy, creditor proceeding, lawsuit, divorce, whatever, we hold that inheritance in the trust estate with no ability for the successor trustee to distribute it, because the condition has not been met, because the child is not free of legal proceedings. Other children who are free of legal proceedings can get their inheritance. Has nothing to do with them, but it does with that child who's involved in a lawsuit, etc. Secondly, a second condition is a child must create their own sole and separate property trust to receive the inheritance. That then identifies any funds, any real property, any stock or whatever as their sole and separate property. And they create the trust, and we transfer, the successor trustee transfers it from your family trust directly into that child's sole and separate property trust. And being identified as sole and separate property, it doesn't allow the child to commingle, at least at that point. They can certainly take it out later on and do whatever they want with it, but at least it gives them a thought process of what you're doing, so now you're making the decision for them. They're not making the decision to create their own sole and separate. You're making the decision as a condition for them to receive their inheritance. And why is that important? Because let me tell you, once you pass away and your child says, oh, now I'm going to create my own sole and separate property trust, and that spouse is going, why? What are you doing? We got mortgages, we got car payments, put it in a joint account with and let's use both our funds, et cetera, then that child has to make that decision on their own. And it's very difficult to do. I will promise you that. But if you make the decision for them in your own family trust, they must do it to receive their inheritance. So those two conditions are placed in the protective inheritance trust provisions. I call them the pit provisions, like a pit bull. So we can hold on to that inheritance and make sure the children receive it, not some unintended son-in-law, daughter-in-law, third party, or some person you have no idea that came out of the woodworks after your death. Now, there is one thing that I'm going to ask you to do, and I may as well go ahead and introduce this now. At the end of the presentation, we're going to talk about a very important document, some homework for you. It's called Letter of Wishes, and we may as well start right now. Letter of Wishes that I'm going to be discussing in much more detail at the very tail of the presentation has to do with what you want to see happen to your estate. And you're going to write it in very layman terms. For instance, if we have a child that's involved in legal proceedings, they're entitled to receive some money. They may need it for their necessities. You're going to tell me in that letter of wishes what exactly you would like to see happen. Then I can frame it in the correct legal terms so it still protects their inheritance. But this is one thing. It will give a little bit of discretion to your successor trustee in how you want that inheritance distributed. All right. I want to move to special needs trust because this is a fairly awesome task for any successor trustee. Sometimes we have children, grandchildren, maybe other relatives or whomever you're leaving your estate to that have a disability. And under our California law and federal law, it allows us to create these types of trusts called special needs trusts. There's two types. There's a third party and a first party. A third party trust is one in which you deal with. For instance, you say, I have my estate, I want to leave $300,000 of my estate to my disabled grandchild, who is, incidentally, receiving SSI or Medi-Cal at this point in life. If you leave them that money outright and free of trust, it will disqualify them from benefits. The special needs trust laws allows us to create these trusts to receive the funds from your family trust estate and to use the funds to give these children, grandchildren, or whomever a better quality of life and still retain the Medi-Cal or SSI or what, and that's typically the government benefits that they're on when we create the trust. I'm not going to get into the technicality of a first-party trust, but that's a D4A trust under federal law. It's a little bit technical. We do those as well. But under those circumstances, the child has received an inheritance and they create their own trust in order to retain their Medi-Cal or whatever, but the state becomes the beneficiary after their death. In a third-party trust, you can make your other children or heirs the remainder beneficiaries after the death of the disabled child. As a successor trustee of the special needs trust, we must give notice to the state of California that we have such a trust. And I've just done two, one very, very large settlement from a Gladium case, a malpractice case. Of course, I don't do medical malpractice. It was referred to me by an attorney in Texas. But this particular trust, we gave notice to the state, and the state responded, yeah, we want to take a look at it. We want to see if there's an opening there to disqualify the beneficiary from any benefits. And they will review them very closely. Once we give the notice, whether it's a first party or third party trust, and the state has an opportunity, we welcome them to take a look at the trust. And at least thus far, we've had no response by the state to object to it, to contest it, so we feel very fortunate. And I got to tell you, they will contest special needs trusts. The successor trustee we have a letter of instruction that we give to the special needs trust successor trustee that outlines what they can do, what they can purchase, what they can't purchase. Bottom line is, do not give funds to the beneficiary. the disabled child. You just can't open up the checkbook and start writing them checks, and you can't do that. It violates the law, and that has to be reported. Any funds they receive has to be reported, and they will lose the benefits. So the successor trustee of a special needs trust, and please move the presentation slide, please, at this time, must be very cognizant of the fact that they are walking a fence line of things they can do, don't do, but we're there to provide them support and help and advise them on the type of assets they can purchase for the trust and the assets that they shouldn't, and certainly not give money to the beneficiary. All assets that are purchased, it's imperative that records be kept. And this is true whether you're a successor trustee of a special needs trust or the family trust or sub-trusts or whatever. You must keep good records. Deposits made, withdrawals made, expenses incurred, reimbursing yourself, and yes, you can do that. Just keep good receipts. And this is an area that is very, very important. And I got to tell you, a lot of mistakes are made. One of the major pitfalls of successor trustees is dealing with annuities and IRAs. Number one, many successor trustees, I'm including the surviving spouse on the death of a spouse, don't understand the law under inherited IRAs. The term is significant. Let's say we have a spouse that's designated as the beneficiary of an IRA. That is a spousal IRA that can be rolled over, or what I recommend is a direct transfer from one account to the other account without getting a check. Typically when we get a rollover, we have a check issued with 60 days to get it back into an IRA account. I would rather inform the institution who's holding the funds, called the custodian, that the spouse wants a direct transfer to another account that may be an existing account for the surviving spouse, an IRA account, or a new IRA account. And thus we don't touch the money. It goes from trustee to trustee. That's what the IRA custodians are called, trustees of the IRAs. However, that situation does not exist for children, because an IRA that is designated for children is an inherited IRA. We cannot roll it over. And we cannot put it in, or we can put it into the account of the child, but if we do that, there's going to be considered a distribution by the IRS. And it's going to be reported to that child's Social Security number. I had a young man a number of years ago. He was acting as successor trustee of his father's trust. He came in. We were sitting across the desk from each other. And he said, well, I just took care of my dad's IRA. I got it into my name. And I said, what do you mean you got it into your name? He said, well, I just went down to the bank and he left it to me, so I put it in my name. I said, did you leave your dad's name on the IRA and just add your name as beneficiary? No, he designated me. Well, what he had done was taken that inherited IRA and made it his own. When you do that, the IRS considers that to be a distribution. there was a potential there for tax on $300,000 as ordinary income in addition to his own income. I said, do you know this bank very well? Yeah, been dealing with it for years. I said, you might want to go down there, leave the consultation right now. We're done. Go there immediately and undo what you just did. Undo it completely. Set up the account with your dad's name on the account. Add your name and your Social Security number as the beneficiary of that inherited IRA. And save yourself a lot of ordinary income tax. He did it, and by golly, they did. He had a relationship with the bank. During that 15 minutes we talked, I saved this guy about $90,000 in taxes. And believe me, he's been very grateful. I've gotten some great referrals out of him since then, trust me. But that's one of the stories, that's one of the nightmares we see with our successor trustees. And as a successor trustee, you do not want to have that responsibility for your siblings or other beneficiaries or grandchildren or whatever. So we want to be able to advise you, counsel with you before you go out and start converting IRAs, rolling them over willy-nilly. That's an important part of the administration. All right, I see we're about halfway through our presentation. We're going to 11:30 today. Please move the slide presentation to the next slide. We're going to talk about some, if we haven't already, talk about some hot issues facing successor trustees. And what I'm seeing in my practice and through the court system, things that you need to do to protect your successor trustee. And I'm talking to you, Mr. Trustor. That's you, Ms. Trustor, the ones who created the trust. Make it easier for your successor. Because if you don't do it, they are going to fall into these holes and these pitfalls that are going to strangle them and really cause some issues, because they're causing issues now in the court system. I want to go back and talk about if you have an AB trust or even a simple trust in which you can provide health, education, support, and maintenance to your beneficiary. This is an incredible out of the court system, but there's been interpretations that if you indicate that you want to make your trust available to your surviving spouse for their support, which is part of the ascertainable standard, we can access principal for health, education, support, and maintenance. Support has been interpreted to mean not only your surviving spouse, but if they remarry their new spouse, and if they have any dependent or minor children. I know minor children normally is not in the situation, but if you passed away young enough, you could leave a surviving spouse that's going to probably remarry and possibly bear additional children. But your trust must support the spouse and any minor or dependent children in addition to your surviving spouse. If you don't want that, we got to amend your trust to say so. If you're leaving a subtrust to children or grandchildren, that includes support, and you don't want to support a son-in-law or daughter-in-law or maybe grandchildren you never see, we need to work on those intentions in your trust. And I've I've got it there. Courts have held that support includes the beneficiary's spouse and any minor dependent children of the couple. And even to this day, I'm having clients, we've had 2 recently, that have lost longtime spouses. And I have, and they're in their late 70s, early 80s, and they want to remarry. And one of them, and certainly I know this happens, but they're much younger than my client. And if we have support in that trust and they do remarry, your decedent's trust, who may be intended for your children, is going under the interpretation support will be support for your surviving spouse and their new spouse. So you need to think about that. And I'm just putting out that warning to you. If that's not your intentions, let's get it in the letter of wishes that I mentioned earlier, and let's get that implemented in your trust. Now, let's move to the next slide, please. And I'm sorry I'm having to continue to do this, but I have no idea what's on your monitor because of the technical problem. Also, for the surviving spouse, we need to set out exactly, because there are issues before the courts. And incidentally, speaking of the courts, they've cut back because of the recession on manpower. And guess what? If you file, or if someone files a suit or contest the trust, do you know there's no court reporters down there anymore on the civil side? You have to bring your own court reporter in. You must bring, in California, you must have your own court reporter, and that is an additional expense. Not only is the filing fees, attorney's fees, but now you're paying for a court reporter as well. So let's get these trusts right and stay out of the court system, because it's much, much, much cheaper to do it now. Get your intentions done so we don't have to deal with trying to interpret what we thought you intended at the time. And here's another area. If we have a surviving spouse, must she expend all of her or he, all of their Trust A assets before we can get to Trust B principal? That's something we need to know. That's something you need to tell me in a letter of wishes. Or must we consider other resources of that surviving spouse before invading the Trust B? Because typically Trust B is intended to be preserved by your federal estate tax exemption and ultimately go to your children. If surviving spouses remarry, their one half of the estate is probably going to go into another estate, maybe their new spouse's estate, or to their children. I don't know. But that's typically where Trust B is intended to go to your children as what they're called the remainder beneficiaries. Let's get some definitive details in your trust, how you want to handle that. We also want to avoid conflicts with children and stepchildren. How do we do that? We can include provisions in there of who's been given priority as a beneficiary, your surviving spouse or the children. If you're going to be more liberal with the funds for the surviving spouse, we're going to give that surviving spouse priority. And let me just give you, this is a for instance, and one of the provisions that we could put in the trust. Go to the next slide, please. Because a trustee has a duty of impartiality, the successor trustee must treat the income and remainder beneficiaries without being partial to either one. So they got to walk that fine line. But here's an example. It is, if you want this, it is not my intention that the assets of any trust created hereunder be conserved for the remainder beneficiaries, if this is your intention. On the contrary, my primary purpose in creating this trust is for my surviving spouse's support in reasonable comfort and the interests of the remainder beneficiary are subordinate to that purpose. Now, you may take a different view and say, yeah, my surviving spouse has other resources. He or she has her own trustee. I really want to conserve my half for my children. So we would do the opposite here and state that my priority in distributions to my surviving spouse is actually for my children. So I want to give them priority, and you instruct your successor trustee in that regard. So again, this becomes part of the letter of wishes that we're going to ask that you create. What about, okay, next slide, please. What about life estates? When you leave a life estate for a child or a spouse, maybe the right to live in the residence for a particular period of time, we need to be specific. And again, I'm telling you what's going on in the court system, because a lot of these, and I'm going to give you an example here in a second, a lot of the trusts are not specific. What happens to the residence? If you leave a life estate in it for a child or other beneficiary or a surviving spouse, we must be specific. Who's going to maintain it? Where are those funds coming from? Who's going to pay the taxes? Okay? Who's going to pay the insurance? How long do they have to live there? What if they get remarried? Do they still have a right to reside there if they're a surviving spouse? What if they have to go into a nursing facility and they have what is known as a life estate? As long as they live, that life estate exists, and the remainder beneficiaries have no way, have no ability to sell the property and get their share, even though that individual is in a nursing facility. Maybe you left a life estate for your disabled child, and they have to go into a facility. We're hamstrung because we can't do anything about that property until their death. So we need to be definitive and make it a condition on remarriage, nursing facilities, or they intentionally move away from the property or whatever. Those things must be addressed. What about if we rented the residence? Who gets the proceeds? Do we put it and hold them in a trust for the remainder beneficiaries, or are they intended for the life estate beneficiary? Here's a trust I'm dealing with right now. Let me just read you some of the language. You tell me what we're going to do. Okay, if the trust estate has any interest in the property located in San Diego, the trustee shall retain such property in trust for the trustee and retain a sum of money for her. The trustee shall allow the beneficiary to live in the property rent-free for the balance of her lifetime. The trustee shall pay all expenses relating to the ownership of the property, specifically including taxes, insurance, homeowners, maintenance, repair, etc. If the beneficiary vacates the property, and if the trustee in the trustee's judgment determines that it's unlikely that she will return to live in the property, the trustee may sell the property. And on her death, the property goes to some charities. Wow, the lady is no longer living in the property. She had to go to a nursing facility. There's some dementia issues. She's always expressed an intent. She always wanted to go back there. Does she have a right to? I don't know. Does she really have a life estate? Because the trustee may sell the property. That's what the trust says. May, meaning discretion, not mandatory, discretion. So what do we do? The lady needs she needs more funds. She's in a nursing facility because that estate is dwindling down. That fund that the trustor arranged for is dwindling rather quickly, and she's in great health except the dementia. If we can rent the property, we could help supplement her situation. Can I do this under this trust? I don't know. I'm not sure. That's something that I may have to ask the court for an instruction on. And here's a trust written. These are lifelong friends. She wanted to benefit this lady. But this is what I'm talking about, exactly. If she had a letter of wishes implemented into her trust that specifically said, I want this place rented, as long as my friend is alive, she's entitled to those funds, it would make my life and certainly the successor trustee's life much more easier. And ladies and gentlemen, that is a prime example of what we're talking about. Because I'm not sure if we rent it and hold the proceeds for her, is the trustee acting impartially then? Or is she only acting for the income beneficiary, the life estate beneficiary, if indeed it is a life estate? Subtrust for minors, grandchildren's education. Typically, we see in most trusts, we have a provision that if a child is deceased, it goes to the living issue. That could be your grandchildren. It could even be great-grandchildren. That's what issue contains, and it's part of the definition. It will say that I provide for their education up to the time they're age 25 or 30 or whatever. And therein lies the problem. What is education? Are we including the lower education, middle school education, high school education? Education, mostly people think of college, some university, someone seeking a degree. Does it include the technical degrees? What if they don't want to go to college? What if they don't want to go to a university? Does it include going to a school to learn a trade? I don't know, because I'm not told that. And this is something we've got to be more specific in. Otherwise, it's left to the courts. And if your successor trustee provides something, what if it's for their own children that they're providing education for whatever reason? You've left a fund for them. Is the successor trustee then in trouble with other siblings if they do provide education for middle school or high school? What about study abroad, which there are a lot of college kids that are going, and please move the slide again to the next slide. There are many kids going abroad for a year. Does that include education? We need to and also, can they educate themselves to age 40 or 50 or 60? Some people are going back to school now, believe it or not. Yes, they are. In their 50s and 60s, they are going back to school. Are you going to set a limit by age 30? Or set a number of years? These are the things that you need. Are they going to have a certain grade point, or can they still get that education fund if they've got a C-minus average? Or are you going to require they have a C+, B average, or what? Letter of wishes. I need to know these things. It's incredibly important. We don't want to leave it to the courts, and that's what's happening. That's why I'm bringing you this presentation, to put you on notice. Let's get it done now the way you want it, not have some judge that you never knew and never will know interpret your intent. Accounting problems. Next slide, please. Getting letters, emails. The trustee is not accounting to us. A formal accounting is required by the trust. We've not seen a formal accounting in the last 2 years or 3 years or whatever. Hey, let me help your successor trustee out. Let me tell you how. Instead of a formal accounting in your trust, indicate that they can do a summary letter, a trustee summary letter of deposits, withdrawals, expenses, and include copies of receipts. Otherwise, a formal accounting typically goes to a CPA, and we'd have to do, under the probate code, all these bells and whistles. It's costly. Make it easy for them. Indicate they send out a summary letter every 4 months or what, quarterly, whatever, twice a year, whatever. Make it simple. Trustee fees. Let's not use reasonable. Please go to the next slide. Let's not use reasonable. Let's say exactly what you want to pay them. How much per hour or percentage value of the estate valued on December 31st of every year. Whatever. But let's get something definitive and get away from conjecture. Personal property issues. Again, I'm looking at my notes because I can't see where you are on the monitor. Personal property issues, believe it or not, are big-time problems. Photographs, guns, wall paintings, furniture, everything you can, jewelry. Oh, yeah, jewelry's big. If you want this to go to a specific person, make it easier on your successor trustee and state it in writing on a specific bequest format, which we have, we can provide, and attach it to your trust. If you say, I don't know, several of them want this picture, then have some kind of lottery selection or select by age or whatever. But define something for your successor trustee to follow, a roadmap to do this. It's extremely important. You would think not, but it is. So anything that you possess that your children, you think there's potential to fight over, let's get that problem solved now. Next slide, please. Incentive trust provisions. I was sitting around thinking, what can I do? How can I make this so the clients can see the real importance of what they're doing when they leave an inheritance? It's very important. It's not you just passing away and leaving this willy-nilly or 3 equal shares or whatever. It should be well thought out. You know your children. You know your grandchildren. You know your heirs. You know their inclinations in life. You know, or maybe you don't, but you probably have a pretty good idea of some of the bad habits they may have. And sometimes we have to own up and accept that fact. there is a way you can use your inheritance to enhance their lives. And these incentive provisions are intended for that. I have indicated that money talks. If a beneficiary has to achieve for an inheritance, these incentive trust provisions will do the following. They promote, please, next slide, please. They promote achievement. They will build appreciation, that not just to take your estate for granted. Like I'm a child, I'm going to get it. I don't have to do anything. It causes respect for what you did in your life to build your inheritance. And I don't care if it's just one home, just your residence. You are the one that went through life that acquired it. And I'm not talking, I do have clients that have many, many properties, but I'm talking to you two, the person that just has their residence and a conservative account. This is something that you're leaving. Make them respected. I have something this type of incentive should provide substantial reason to avoid substance abuse, gambling, and what I call way low. And that's wasting a young life on waiting. And if you don't think I've not seen this, trust me, I have. I've seen it personally. All they're doing is waiting to inherit. What you're doing, if you allow this, is you're igniting the flame, ignoring idle trustee endeavors is what I call it. I sat around and made these terms up, acronyms. But you're igniting that situation by throwing gasoline on an already existing flame of bad habit. You're only going to give them more ability to drive themselves deeper into that bad habit. It may be lack of family commitment, be lack of education, substance abuse that I've already mentioned, unemployment. Don't allow it to continue. And people say, yeah, I'm controlling lives from the grave. Yeah, you are, but it's in a positive way. If you don't, you're going to leave your inheritance in a negative way. It's going to be wasted. Everything, and when I say everything you've acquired, meager or great, it's going to be wasted. So I highly recommend we include detailed incentive provisions for these beneficiaries. Next slide. I have put in large letters, courts are guided by a trustor's intentions. That little trust provision I read to you a while ago with the two older friends at leaving this home or for this lady. What was the trustor's true intent there? It's very difficult. It's very difficult. Don't make your trust difficult. Make your intentions known. And that's why I'm asking that each of you in our closing, I want to discuss in our closing few minutes here, to prepare a letter of wishes. Go to your distribution. Go to your minimum age for outright distribution if you have, or potentially if a child would pass away and you have younger beneficiaries. Go to any B trust if you're married with an AB trust. Tell me what your priorities are. Write them down. You can mail them, email them, send them to me. I want to know. It's confidential. It's going to go in your file. It's not going any further than you and me. But I can glean from your letter of wishes what you intend by your distribution, by holding in subtrust for your surviving spouse, subtrust for children, minors, disabled children, protective inheritance trust provisions that I know probably 85% of my clients have put protective inheritance trust provisions in their trust. I can see and read. Then I can tell you, Mr. and Mrs. or Mr. So-and-so or Ms. So-and-so, we need to put this in your trust to this extent. I'll reframe it, obviously, from a legal point of view, and revocalize it to some extent, but the intent will be there. And that's what becomes important, because that's what the courts look at. And in fact, if you have that intent embedded in your trust, the potential for contest is reduced to zero. And what not only that, you allow your successor trustee a lot more ease in the transition and in determining what you intended and using discretion based on your wordage. Makes it a lot easier for your successor trustee and in the administration of the trust. So I highly recommend, please go to the next slide, that you prepare, and that's homework for you, those letter of wishes, and I will interpret that and get back to you. I'll respond to you whether I think it should become a part of the trust or not. If there's a couple of questions I know people are asking, and I just went ahead and asked, will the letter of wishes become a part of the terms of the trust? If it does become a part of the terms of the trust, it becomes binding on your trustee and enforceable by the beneficiaries. If it's not a part of the trust, it's only advisory for the trustee, but it's not binding. So the trustee can ignore it if they want. So that's why I have to read and see what you intend by each. Can your letter of wishes be changed? Of course. You can change it at any time, just like you have an amendable trust. If I have the letter of wishes in your file, you can change it at any time. If we make it part of the trust, you can amend it at any time. But I need to see your letter, that's the last statement, to determine if it should become a part of your trust. These things we have discussed in the last hour and 15 minutes. Okay, you should be on the last slide, I'm told. In the last hour and 15 minutes, we have run through them rather quickly, but there are things that you need to address and determine to make this easier for your successor. Who is your successor? Do you know? I will promise you, I've asked that of clients when they come in to update their trust. They say, I assume it's so-and-so. I believe it's so-and-so. I'm not sure. It's been a number of years. Your successor trustee is the most important part of your trust. Is as important as your distribution. I want an available successor trustee. And what do I mean by that? Do I mean they have to be living next door? Do I mean they have to be down the street from my office? No. We have successor trustees all over the country. They have to be available to a phone call, available to an email, responsive, that's available. Responsive, dependable. I would rather have someone in New York City, in the middle of Manhattan or wherever, that is more dependable and responsive than someone in La Jolla, if that's the case. Because I know things will get done. And we do it all the time. We do it by email, overnight mail, everything these days. It makes no difference. They don't have to be living here. Make sure, and you have your successor. We want a first, second, and preferably 3, but 2 is okay. First successor and a second successor. All right, am I able to see any questions? Incidentally, am I able to see any chat questions? If people have often asked me, you do these trust administrations, you're dealing with the IRS because you're getting a tax number for the trust. Yes, we are. It's like, hey, we're here, we're in existence, we've got a trust, it'll eventually file a tax return. Did the IRS, have they ever come back and rendered anything void or create a problem? I can tell you that all the years that I have done trust administrations, and I'm knocking on wood, we have not had any IRS audit of one of my trusts. So that I hope that gives you a little peace of mind. It does me for sure. Because what we want to do is try and get the trust prepared before your death or disability, so there is no issue, so there is no question, so there's no surprises, so your child can come in and we lay it out of what's going to be, and chances are they may have already seen a copy of the trust. I don't know. That's up to you. I can't provide it to them. You can. But again, I want to go back and emphasize this because it bears repeating. If you've amended your trust and all amendments will go out to all beneficiaries listed in your trust. To avoid that, complete a restatement in its entirety, and we supersede everything that's gone on before. Any chat questions?
Jack, this time we don't have any chat questions, but if you would like to ask a question, you can type it in on the chat box to the right of your screen.
Okay, we'll await that to see if anyone has any questions. Since we have a few minutes left, I want to close by saying that I would look forward to hearing from any or all of you that have heard my voice today. What we attempt to do is to provide you information to keep your estate out of the public court system. That's what we're trying to keep it, a private contract. That's what it is. So these things that we mentioned enhances that purpose. Additionally, I'm creating some alerts. I'll be creating some articles for my newsletter, which is Trust Attorney Trustee Advisory. This is part of the Trust Attorney Trustee Advisory. And next month, be sure you should be getting all of these articles. If you're not hearing from me, these articles or alerts may be going to your spam. You need to check and with your server provider and see what the status is, because these are important matters that we send out by email. We're not doing mail any longer. So it is very, very important. Also have a Facebook page. You can search Law Office of Jack E. Stevens. Remember, my name is spelled with a PH, not a V. All you need to do is check that out, Facebook page, search Law Offices of Jack E. Stevens.
We do have a question here.
Go ahead.
Cecilia has asked, Do you recommend co-trustees?
I have a question. Do we recommend co-trustees? And I'm often asked very questions. Very good question. Usually not, unless it's assured that the co-trustees can and have had a history of acting together and in concert. If they don't, it is a nightmare. And incidentally, I had that nightmare with two sisters, one in San Diego and one in Orange County, and that lasted for a lengthy time at a lot of cost. Eventually, they got together, thank goodness. But you don't want a situation where the co-trustees have different attitudes on issues. If they can act jointly and they have a history of it, okay. I would rather deal with one person because we can send the documents there, get the signatures, get them back. Otherwise, it's got to go to two different places. And I just have a trust now we've got 3 co-trustees. So imagine we've got to go 3 different destinations to get signatures. If that's what you want, that's fine. I don't recommend certainly 3. 2 maybe, 1 I prefer. Any other questions?
No more chats at this time.
All right, and finally, I would like to just say to you, next month, be looking for some articles coming out on elder law. You know, I write the elder law advisor as well as the trust attorney trustee advisory. So in those 2 newsletters, you'll be seeing some parts of articles. And we have, you can go to my website, and there's an archive of some articles that I've written that you can download if you wish. If you have any questions regarding any follow-up questions you didn't submit today, please email me at my office, jes@jackstevens.com. That's JES, my initials. All you need to do to get all my contact information, Google Jack Stevens. I pop up. Have a great day. I look forward to hearing from all of you, and God bless you. Bye-bye.
This concludes today's webinar. Thank you for attending.
The moderator has ended the conference. Goodbye. Thank you for calling.